Amber. Thank you very much for accepting my invitation to speak at the interview series of the Euclid Center. We have finally restarted these interviews after a pretty long break after the last summer. And how could we better restart if not with a great interview with Dr Darr. We were discussing, I will introduce you in a second. I want to create a bit of suspense, but we were just a second ago discussing about, before starting the recording of this interview, discussing why I decided to start this interview series. And I told you that one of the reasons why I decided to do this, because the country where I live now is fantastic, but it's a little bit secluded, and it doesn't really allow me to be exposed to as many interesting people and ideas as a country like the UK, and in particular London, when we used to live there together. Allows, obviously, these kind of cosmopolitan cities have a different offer different chances, cultural chances. So what I decided to do is to start this interview series exactly to be exposed and engaged with very interesting ideas. And I find that Amber has, in her research, but also in her lectures and in the conversations that I usually have with her, has this kind of has always something very interesting to share, always new view, in a different view that's an original view on not only on competition law, but in general on developmental studies, competition law, corporate law, and comparative law, and you name it. Indeed, Amber is an extremely, this is for everybody who will listen to us and doesn't know her, and is an extremely versatile lawyer and economist. She's a lecturer at Coventry University School of Law, but also a senior research fellow at the Center for Law, Economics and Society, and a teaching fellow at UCL. And she works, as I said before, in different areas, spanning from competition law to law and development, comparative law, intellectual property, and company law. She holds a PhD degree from the University College London Faculty of Laws, and she's also a barrister of Lincoln's Inn and an advocate of the Supreme Court of Pakistan. Indeed, she's based in London, but she's originally from Pakistan, which means that she understands both the development of laws and competition laws, in particular in developed jurisdictions, and in particular Europe and the UK, but she's never lost her strict ties with Pakistan, and to a certain extent also India, that she always that she studies, that she always focuses in her studies. So these capacity, this skill of that you have of being able to understand both developed and developing jurisdiction allowed you to write these two papers in particular that we are looking at today, which have been published both, I believe, right?
Yes.
Okay, so the first one would be the role of institutions in generating successful legal transplants, a comparative analysis of the adoption of competition laws in India and Pakistan. And the second instead is more related to the enforcement of these laws that have been transplanted, and regards the role of courts in enforcing competition laws in India, a comparative analysis of India and Pakistan. So with these two articles, what I believe, you start from a very interesting point, because development studies usually take the lead and start from the assumption that once an institution is adopted, then we need to design certainly that those institutions in a way that is compatible with the local environment. But in general, it's as if this institution has been created from scratch. While you take a step back and you say, hold on, very often, if not always, in developing countries, these institutions are imported from abroad. So let's take a step back and see what does it mean to import something from abroad? In particular, what does it mean to have a legal transplant of an institution? And as all the transplants, these transplanted external body can be rejected at some point. So let's see when and how and why this gets rejected. So, and here you studied through the lens of comparative law and development studies, to analyze these legal transplants. Could you say a little bit more on that, please?
Yes, thank you, Claudio, and thank you very much for inviting me to speak from your platform. I think indeed it's one of the gifts of the pandemic that we can use, virtual means of communication to reach, wider and wider audiences. And I'm absolutely delighted to join you here today. Thank you also for the very kind introduction. I hope I live up to it as we go through this interview. So let me begin by, again, thinking about your first question. You asked me about legal transplants and what causes them to be accepted or rejected, or can laws easily be transported from one country to another. I think this is my starting point for this discussion, is to say that it's a reality. Laws do get transported from one country to another. Indeed, they have been transported from time immemorial. So even when the Romans were invading the world, they were carrying their own systems and their coded laws to different parts of the world. And a lot of the civil law countries that we see are based on the laws that arrived at that time. Again, closer to home, or at least my original home, which, as you rightly said, is Pakistan. Pakistan was the subject of receiving a lot of British laws during the time of the British colonial period, which lasted for nearly 90 years, from 1857 to 1947. This is also true for India. So I think, having said that, they're always a reality. Laws are transplanted from one country to another. I would also go so far as to say laws should be transplanted. So there's merit in borrowing laws, because why should you reinvent the wheel? If a solution exists somewhere, there's definitely merit in borrowing it. That brings me then to the third point, which is, how do we borrow it? Do we borrow it blindly without thinking about it? Do we only look at results in the original country? For instance, if a competition law has been operating in the EU and it's working really well, it's efficient, are we just going to accept it into our own system and in the expectation that it will be as efficient in another country, in a different context? I think that's where the thinking, my thinking at least, has been focused. I also drew a lot upon, you mentioned I looked at comparative law and development studies. I also looked at diffusion of laws. So I also looked at how laws spread from one country to another, and what are the motivations through which countries adopt, or for which rather countries adopt laws. And then I want to think about what kind of thought process and what kind of engagement happens in the adoption process. So to speak very briefly about this, there are two sort of polar extremes. There are different, or I would say three main ways in which laws are adopted. The first is what I alluded to, imitation. It's also called copying. Sometimes the literature refers to it as mimicry. So you just see a law working somewhere else and you pretty much adopt it as it is and you bring it into your own context. That requires very little engagement from the local setup, and you just sort of borrow something. Quite often it is based on your perception of the law or your perception even of the country. So for instance, if I'm living in Pakistan and I'm really impressed by the way EU does everything, I might just want to borrow an EU law. In reality, post-colonial countries have a great attraction for UK laws because they have that great attraction for the UK. It doesn't always mean that the UK is best for their context, but that's where mimicry comes in. That there's a lot of reasons that you borrow laws which have not much to do with how the law would actually function. So mimicry is one, which we all understand. Then there's another one, which is perhaps on the spectrum of most desirable to least desirable. This would be the most desirable. I refer to it as socialization. And this is when you take a law, when the law is coming in from some other country, but there is actual engagement from the local context as well. So let's say I want to borrow a UK law. I'm sitting in India and I have enough scholars and experts and policymakers on the ground in India, and they study the law, the system, and they engage with it. They adapt it for local context. They say, well, this will work for us, this will not work for us. And then they change it, they tweak it as it needs to be tweaked, and then they adopt it. So that's called socialization. That has local input as well. The third mechanism through which laws travel and policies travel is actually perhaps the most common, and the literature refers to it as coercion. And I just want to be very clear that but coercion is a legal or a diffusion political science term. I don't mean somebody is twisting our arm literally, but there's a lot of overt or implicit pressure that can be brought to bear on developing countries in particular. For instance, I'm IMF or the World Bank, I'm giving you a loan and I say, okay, for this technical assistance that or for this loan rather that I'm providing you, there's a condition that you should also, revamp your institutional structure in your country. One of the things I recommend is that you borrow a competition law. That kind of coercion, again, it's top down, so it's not often doesn't often engage very well with the local experts. Quite often there isn't a local expertise, so the law doesn't get adopted or adapted, I should say, before it's being adopted. So I think just to sum up and come back to the original question, laws are borrowed. That's a reality. Laws perhaps should be borrowed or adopted, because borrowed, I find a strange word because we're not giving them back once we take them. So yes, they should be adapted. However, perhaps it is important to bring an intelligent mind to the process of borrowing and adapting the law for local context. What I say in my papers is that that's not just a theoretical need, that's not just a nationalistic desire, but it's also important for how the laws will then be implemented going forward. So I hope that answers somewhat your question.
It answers splendidly my question, and actually I see many of the typical traits of the legal transplants that took place here in Kazakhstan, for example, in other Central Asian countries, because what I could see by interacting with the antitrust authorities and studying the history of competition law in this area of the world is that there has been a bit of all these three types of implementation of competition law. There has been mimicry, but also lots of socialization, especially in the post-Soviet area. And there has been also this coercion that I agree with you from a legal standpoint. It doesn't really sound right. It's probably more a sort of economic duress, if you want it. that sometimes is used also in situations that, again, in economic terms, could be more defined as a hold up, right? Because once you are borrowing money from me, then if you want that money, if you want that loan from me, then you gotta do what I ask you to do. So that comes as a sort of unintended consequence of the loan given by international organizations. So I've seen that there have been all of them, and so these are typologies that can be very effectively used also in practice. So I really like them. But then in your paper, you also continue by saying, all right, so once we understand how these laws have been imported or transplanted, in more technical terms, have been transplanted in this country, though just like in any other transplant, there is the risk of rejection, right? And so you try to understand how and when these rejections take place. And in particular, you analyze two concepts, the concepts of compatibility and legitimacy. Can you expand a little bit on that, please?
Yes, absolutely. So I'll begin by saying a little bit about what it means for a transplant to be rejected. And I think there's enough literature. There's Otto Kahn-Freund, for instance, who specifically talks about rejection. There's Alan Watson, who refers to rejection. What do we understand by the idea of rejection? And rejection doesn't mean the law growing in a different direction from what was originally intended. That's not rejection. So what is rejection? I spent a lot of time thinking about it. And to me, it seemed that I would say a law is rejected when it remains a law on the books, but never becomes a law in action. Again, this terminology is not mine. This is the terminology adopted by law and development scholars back in, I'm sure quite, Claudio, you must be aware, and I'm sure the audience is also aware of the 1960s. There was a big movement on law and development. And one of the reasons that that movement scuttled and wasn't very successful is because they were actually taking legal solutions to countries without adapting them for context. And that brings me then to the two ideas that you mentioned in your question, which are compatibility and legitimacy. So compatibility is quite well understood, although it's not really defined anywhere. So I was literally looking at dictionary meanings of compatibility. Compatibility with what? That's a critical question. What should be compatible with what? And how do you create compatibility? And then what is the effect of compatibility? And the same with, so let's speak of compatibility first, and then I'll come to legitimacy. So compatibility then is a deep structural compatibility, not a superficial compatibility. So not just a compatibility of language or, you know, sort of seeming compatibility of culture, but also looking at the deep institutions of the state. So for instance, to use the example I was working on, I was looking at what kind of legal systems, what kind of political systems do they have, what kind of economic basis do countries have, and are they borrowing laws from similar situations, and what? So that's the compatibility that you begin with. I also wanted to look at how compatibility can be created. So, for instance, if I'm from Pakistan, I don't want to borrow laws from India, although I probably have the most initial compatibility with India. I actually want to go better, and I want to, what I think is better, and I want to borrow from the EU, which is exactly what Pakistan did. So how do I take a law which actually comes from a very different starting point, very different baseline, and make it more compatible with my concept, with my context? In that, the development literature was very important. In fact, it was the only space where I could find evidence of how compatibility can be generated. And one of the books and chapters, rather, the papers I found most interesting was Danny Roderick's chapter on economic recipes, and one recipe and many economies, I think it's called. And he talks about generating compatibility through participatory institutions, which bring the local knowledge to the institution that is being adopted. the discerning amongst you, and Claudio, I'm sure you would see that this echoes with the idea of socialization, except that here the socialization is taking place through a particular type of institution. So in my research, I said, you don't have to be compatible to begin with, but you can make a law more compatible by the process through which you adopt it in your country. So for instance, a participatory process would look like a democratic process where you actually table the law before Parliament. The Parliament has a standing committee, it sends off, discusses with stakeholders. Maybe the government sets up a committee for reform and they go and discuss, what the country's needs are. They develop a feedback loop with the populace, and then they use that feedback loop to adapt the law. And a law which is adapted in such a way through participatory institutions is more compatible with context. So it's not imposed top down, it's not given to you as an order or an instruction, but it is actually something that you've understood and you have brought your own perspective to it, and it becomes more compatible. Now, there was one thing that was still bothering me when I thought of compatibility, which was, what makes people accept the law? What is that one psychological or philosophical thought that makes them accept the law as valid? So for instance, I was observing the Pakistani competition law. Pakistan adopted its first competition law, a modern competition law, because it had a monopolies and restrictive trade practices law from the 1960s, late 1960s, early 70s, but it adopted its first modern competition law in 2007. That law, and we can talk about it in more detail as we go on, but it experienced some issues. Around 2014, it was practically not working. There was nothing happening. And that to me is what I said earlier, looked a bit like a rejection. Are they just going to ignore this law? And when I went into it more deeply, I realized that people were not really approaching the law. So the law had never really become accepted. So this idea of acceptance was very interesting for me. And I wanted to find, what is the legal and philosophical basis for acceptance? And that's where the concept of legitimacy comes in. And what is legitimacy? So political philosophers, it's a political philosophy concept, and they talk about legitimacy being a subjective idea, that a law is legitimate if I believe it to be legitimate. Why do I believe it to be legitimate as a citizen of a country? Because it came through the right source. For instance, if I have a king in my country, the king declared it to be the law, so the law must be legitimate. A law is legitimate if it's just, but we're not going to get into justice because justice is again so difficult to talk about. But law is legitimate if it has authority, if it can sanction. But also, and I think this is, again, there's some research on this, and I can refer you to it in a bit. A law is perceived to be legitimate. It has that critical domestic legitimacy if people have consented to it. And that to me I could see the parallel between the participatory institutions that are creating compatibility. And I saw they're not just creating compatibility, they're also creating legitimacy. They are conferring on this law that was brought in from outside, they're conferring that layer of acceptance. Again, in a lot of developing countries, what is consent? What are we consenting to? What kind of democracies do we have? Those are big questions, political science questions, which I wasn't going to get into. For my purposes, it was enough to see that there was some constructive consent, that there was some effort that was made to bring in the public, either through experts or through elected individuals, and to develop a consensus that this law was desirable and needed for that country. And that legitimacy, I felt, went a very long way in ensuring a better implementation outcome for the law. Again, like compatibility, I just want to add here that legitimacy, just like compatibility can be enhanced in the adoption process, legitimacy can also be enhanced in the adoption process. So legitimacy, again, is not a condition that exists always at the beginning, but it can be created. It can be enhanced through the mechanism through which you bring the law into the country. So if the law is brought in with some consent, you're actually gaining both. You're gaining the the knowledge and the priorities of the local populace, but you're also gaining their acceptance. And these factors then, compatibility and legitimacy, they go a long way in implementation. And as we go along, I can talk to you about the link between implementation and compatibility and legitimacy as well.
Yeah, this is actually, this reminds me a lot of, there is a saying here in this part of the world, in the post-Soviet countries, that translated would go more or less like this, that the strictness of the laws is tempered by the laxness of its application. And, you know, it really resonates with me when you tell me that the law in the books might be even perfect when a legal transplant is executed, but then if there is no real compatibility and legitimacy of the law, then the law in action will look completely different. Or maybe it won't look at all because it's not is not used at all. Because this rejection may take place both on the side of citizens that don't recognize the law, or even on the enforcers that do not really see themselves reflected in, you know, in the concept and in the principles of the law. And by the way, we talked about participatory and grassroots initiatives also in an interview with Tommaso Ferrando. I know that you know him. And he was looking at this kind of initiatives, so bottom-up initiatives for the creation of legal institutions in the sector of finance. But I can see lots of connections between the researchers that you are doing in competition law and that he was doing and probably will continue in the realm of finance, international finance, and grassroots initiatives. So this is even more interesting now because I can see these connections. And so indeed, as you said, that there is this risk of rejection that can take place either at the beginning, but that can be somehow mediated by the local legal and political institutions in the adoption of this law. So what do you think is the role of these institutions in implementing these laws?
Okay, so when we think about implementation, you know, we touched upon the idea of rejection, but I think it's also really important to touch upon the idea of success. So we understand what rejection looks like. Rejection looks like the law stays on the books, it's never implemented. But what would success look like? Because if we know what it looks like, we can work towards it. So again, to me, and after reading a lot of different things, success to me looked like the adopted legal framework engaging productively with the pre-existing legal framework. So imagine a real transplant. When I say a real, an organ transplant, that's the idea that when we think of transplants, we think of organs. So here's a body which pre-exists. You're going to bring in a foreign thing and you're going to put it into this pre-existing body. And we would say the transplant is successful if it can interact productively for the goals that you wanted, that, you know, if you're not borrowing, but transplanting a kidney, then you want it to do the work that a kidney does, rather than, doing the work of a lung. You don't need the work of a lung, you need the work of a kidney. So if it can interact with the other organisms in your body to create outcomes, and we won't even go into the quality of the outcomes. I think that's an economist's issue, that, is the society becoming more competitive, or, you know, have you been able to break up cartels? That's a very important point, but that was not my point. I think there are enough economists and working on the state of competition in different countries. I just wanted to understand what is going on behind the scenes. So to me, success looks like, the starting point of success is that productive interaction between the pre-existing legal system and the transplanted legal system. And how do we measure it? So to measure it, I wanted to look at whether the laws were understood, applied, and utilized in the countries in which they were being transplanted. So if these three things were happening, then perhaps we were at the place where we could at least work towards successful outcomes, and then we could look at what the goals were. So this sort of resonates, your question or your comment before the question, and you said something very interesting. And when you said that the rejection can be by the people, but it can also be by the enforcers. I would add a third category who can reject, which are the adopters themselves. So the parliament or the government, in many cases, the adoption takes place through governments. As an executive order, it doesn't go to parliament at all. It is simply top down. I can give you more examples of that as we go along. But what if I adopted it? I picked it up without understanding it. Tomorrow the government changes, they have no understanding of why it's there because there's no broad-based consensus. So they stop giving it support. So if I stop giving it support as the adopter, how do I stop giving support? I stop funding it. I don't create the infrastructure. For proper competition implementation, first of all, I need the infrastructure. I need a competition enforcement authority. I need an appellate tribunal. I need the judges to understand how, what this is about. But no, I did not engage with any of them at the time that I was adopting the law. I did it on the quiet. I did it quietly. As a very in camera, as we say, as a very private activity. Nobody really knows. So it is being rejected, not because somebody has even applied their mind to it, but it's being rejected for non-understanding. So that's the rejection on the part of the adopters themselves. What about the part of the public? The public has heard maybe that a new law is on the books. They have zero idea of what they're going to do with it. And because it's so confusing for them, they just ignore it, absolutely ignore it. Now that to me is worse than using it badly. For instance, in India, we saw in the early years of implementation, that there seemed to be some confusion whether a competition law is actually a consumer protection law. So India had a huge amount of consumer protection type complaints in its early years. I thought that was a good thing, because with every new complaint, there was more clarity. And the law started gaining more traction and foothold. In Pakistan, what did we see? We saw nobody was using it. People were hardly filing any complaints because they had really no idea. So just to sort of backtrack a little bit, India used more socialization for their adoption, whereas Pakistan adopted as part of a conditional package. So people were not using it. That's the other extreme. Third, the courts. Again, one more institution, the judicial system, which is to me the gate through which a lot of legitimacy can occur through the implementation process. So for instance, let's imagine we are in a situation where the law that we adopted was not adopted through democratic means. There was really very little consent. So on paper, it doesn't have the kind of legitimacy and recognition that a law that had been adopted through democratic means would have. But then the law generates activity. People use it to file action. It gets more legitimacy. Then that action is challenged before the court. What do the courts decide? That gives it further legitimacy. And it starts entering the public domain. It starts entering the popular wisdom or knowledge. And that goes a very long way in making that law engage productively with the legal system. So in order to understand that, I spent a lot of time looking at how courts react to laws, because courts are the biggest gateway, the local courts, the domestic courts of each country, the biggest gateway for welcoming the law, bringing it into the legal context. And I, as a Pakistani, would think, well, if my Supreme Court thinks this law is okay, then I think this law is okay. So suddenly the law has more legitimacy. So it didn't have legitimacy when I adopted it, but it has more legitimacy now. The problem is that it takes extra effort to give it that second legitimacy. The courts have to be specially engaged. And if they're not engaged, if they are simply putting those cases to one side and they're not engaging with them, then we are losing out on that legitimacy as well. So again, in the examples of India and Pakistan, Indian courts engaged more productively with their competition cases. And we can see that India, the implementation of competition law has not really been halted at any point, whereas in Pakistan, it's been stops and starts. I just want to clarify that this is not to say that one is better than the other. It is simply to observe that different mechanisms lead to different outcomes.
Yeah, actually, we are trying now to collect all the decisions of the Kazakh courts in competition law, at least since the beginning of the 2000s. Competition law in Kazakhstan here is oddly a long. It's been enforced for a relatively long time. But some decisions are difficult to find, while the decisions from the mid 2000s till today, till nowadays, are relatively easily available, and we are trying to collect all of them exactly to understand how courts contribute to development or hinder the development of competition law in the country. That's exactly what we would like to achieve. And so I find this proposition very fascinating. You know, the role of courts. And indeed, I wanted to ask you about this later, but you know what? I'm gonna ask you now because it's too interesting. So knowing that courts have a fundamental role in deciding how the law in action, but eventually in the future also the law in the books, how the law in action looks like and how the law in the books will look like in a few months or years from now. What do you think should be and is the role of courts in making these transplants coherent and making also the enforcement of these new laws consistent throughout time and space within the country?
Such an interesting question, Claudio, and very close to my heart because, as you said in the intro as well, I've been a practicing lawyer for a long time. So I really find this idea of courts and their role very interesting. So before I sort of really expand upon how I think what contribution they can make, I just want to say a little bit about the thinking process that takes place again at the adoption stage. So when foreign agencies or World Bank IMF has been instrumental, hugely instrumental in bringing competition law to a lot of the world, but also to South Asia, of which I am a part as a Pakistani, they don't really understand the local system. They don't understand the local court system. They understand the technical solution that a law can offer, which is they understand what competition law is, but they don't understand what the local court system is. So they actually pay very little attention. They treat competition law as a quite a specialized technical basket of laws or rules, and they don't worry about how it's going to engage. So a lot of, if you pick up any IMF or World Bank country report, which is discussing competition system for the country, again, I spent a lot of time looking at Pakistan, they never mention compatibility and interaction with legal systems. So that's the first point of disconnect. And that is where we get an idea of how the connection can be made. Now, again, the adoption in India, as I suggested earlier, was quite different. India actually formed a committee which spent 2 years deliberating. It was a local indigenous committee. There were Indians sitting on it in India. They spent 2 years thinking about it. They had lawyers, they had judges, so they could get the feedback of what the courts how would the courts react. So again, these courts are general courts, so they're not technical competition experts. So it's you can understand that the IMF could think, well, what do they know about competition? So we're going to keep competition separate. They may know nothing about competition, but they know and understand and implement the local legal systems. So we as lawyers know that law is not simply technical rules, it is also rules of due process. It is also the legal norms, the implicit legal language of the country, how laws are made in that country, what is considered correct, what is considered not correct. A lot of things that are not written on paper, but the legal system and the higher courts in the country are the living wisdom of that years and years of legal, not just legal rules, but also legal traditions, the due process norms. I think those are the most important things. So for instance, what kind of allegations do you need to tell the other person before um, you can convict them or hold them liable for violation? What is the principle of separation of powers in the country? Can a competition authority also be the judge and the jury, or the police and the judge in the same case? Can it have that? So that's the wisdom that the courts bring. So in India, the minute literally the competition law was enacted, which was in 2002, uh, it was appealed to the Supreme Court. And it was this very famous case of Mr. Bram Dutt, who went to the court and said, this law is not very good because it is contrary to the principle of separation of powers, which is provided in the Indian Constitution. If you talk to people on the ground in India, they say this was some sort of politicking. But as a lawyer, as an academic sitting outside India, I see that actually something very important took place when they did that. So the court said this law needs to be amended, and you cannot have the competition authority being the the person that brings the complaint and also the person that decides the complaint. This needs to be separated. The government went back. They took time to revamp the law. They created the Competition Appellate Tribunal. But also, what that achieved was not just bringing it into alignment with the Indian Constitution, but it also gave a lot of visibility and projection to the law. The Supreme Court understood what the law was about. The public started understanding what the law was about. When the government went back and they reconsidered the design of the law, they engaged more with stakeholders, and there was a further layer of information that was created. So a lot of things happened with just that one action that was brought before the courts. So if you take the enforcement as simply saying, well, how many competition cases have you decided, and that's all you're going to measure it on, you don't understand the support that you're getting from the institutions. I think that is a very weak metric. So the Indian enforcement was very low in the first 2 years. In fact, there was no enforcement. They only started enforcing the law in 2009 properly, when the amendments were made. The competition authority was separated from the tribunal, and then they started enforcing. But when the enforcement started to take place, it happened with the blessing of the Supreme Court. There was that tacit, they had given their extra legitimacy to competition implementation. They had recognized this as a valid law. They said, yes, it's fine. You just need to amend it in a particular way for you to function. Also, there was a lot of public knowledge. And there was that the adopters themselves had given that extra support. So the Indian Competition Act, when it commenced implementation in 2009, the Competition Authority, the CCI, the Competition Authority Commission of India was in place. The COMPAT, which now has a different name, I shall not bore you with, but the COMPAT, which is the Competition Appeal Tribunal, that was in place. The courts were aware that they are the custodians of the due process norms. They have to make sure, their job is to make sure that the competition solution is not violating the other principles of law in the country, that it's always happening with that kind of, it's happening, keeping the integrity of the entire legal system intact. So again, to go back to our transplant example, that the competition kidney that we've put in is not going to poison the rest of the body, and it can engage productively, and you can create a meaningful economic body to operate. So this is what happened in India. And of course, a lot of cases were, as happens in all parts of the world, and especially in Commonwealth countries, the minute somebody filed a complaint before the competition authorities, somebody else challenged it in the courts. The courts have a very specialized challenge that they can hear, which is only the challenge that the general law is being upheld. So the due process norms, the fundamental rights of individuals are not being compromised because of competition implementation. Indian courts quite easily decided those cases because they knew that their Supreme Court had approved it at some level. It had given some sort of a a blessing to it. And things have continued to proceed. Again, there are a lot of variations, which we won't go into, but on the whole, things have proceeded. Now compare that with Pakistan for a second. Pakistan did not borrow the law by bringing it into the discussion in Parliament. They didn't. Nobody ever filed a petition before the Supreme Court when the law was actually enacted. I mean, there was one petition, but that was not on the merits of the law at all. So the law remained very closed. It was not. People were not aware of it. They made a competition authority. The Competition Commission of Pakistan in its early years was very, very strong on enforcement. Some of its earliest decisions were very, very good. But because it worked in isolation with the rest of the country, the other institutions of the country, when decisions of the Competition Authority of Pakistan were challenged before the courts didn't know what to do. And there were many other political reasons also that the courts did not act. But the fact remains that till today, and I'm not exaggerating, this was from 2007, orders of the Competition Authority of Pakistan passed since 2007, 2008, challenged before the local courts in Pakistan, have still not been decided. And I think now it's it's become a chronic problem. It's not just a problem of lack of understanding, of lack of legitimacy. It's also a problem of backlog. So it's become a much, much bigger problem, which could have been resolved earlier by greater engagement, greater capacity building, greater inclusion. Let's say Pakistan had no choice, but it had to borrow the law through the World Bank, but possibly the committee, the consultations could have been wider ranged. It may have slowed down the process of implementation a little bit, but possibly led to a more meaningful implementation in the long run. And by meaningful, I mean that every time the order of the authority is challenged before the court, the first thing that happened, that you get a restraining order on collecting the fine. The first thing that happens. So the competition authority can implement as many fines and penalties as it likes, but it actually doesn't really ever recover them, which translates in economic terms to mean that we don't really make progress towards a more competitive society. So India makes a little bit more progress. It's still a complicated path. There are many, many obstacles along the way, but at least, as I said in the earlier question, that we are on the first step to success. We still have a long way to go to success, but when the institutions are not supportive and institutions have not been included in the initial consultation, either by challenge or in the committees, then really we are in a stalemate position and things just don't happen. And that to me looks like rejection. It's a very long answer to your question, but I hope I answered it.
No, actually, you gave me lots of food for thought. So I was also thinking about what you said at the beginning about, the role of a constitution in facilitating this process of acceptance and implementation of these transplanted laws, and that at the end the real knowledge of this new law. It's also the basis of these fundamental laws establishing the right to a fair process that we have in our constitutions. Because you were saying that you were talking about these inquisitorial models that sometimes are adopted in countries where the antitrust authority is the prosecutor, is the judge, and does everything. Sort of deus ex machina of the economy, and these definitely impact a fundamental right to a fair process, but also the knowledge about the existence of a body of laws that we have to abide, that citizens and businesses have to abide by. That should be also at the core of a principle of fair process. It's true that usually ignorance of the law doesn't excuse the citizens, but when laws are as complex as competition laws, and we know that because we teach them in class, and they tend to be rejected by our students, can you imagine by businesses and citizens that are not supposed to really study thick books on the topics. And I'm wondering, in this case, and this is probably connected to actually our previous question, which was more on the role of institutions. Probably here institutions also need to engage more deeply and more consistently in that role of dissemination and education of market actors in particular, but also the other institutions, in particular the enforcers. So from the antitrust, starting from the antitrust authority, going to the judges and all the other public enforcers that have to deal with this body of laws. And that's a fundamental point. And I agree with you, is not just about the enforcement, the numbers, right? How many times, how many decisions on anti-competitive agreements or abuse of dominance, or how many mergers applications you had, but it's also about how and when and why an institution has been, for example, disseminating information, effectively disseminating information on antitrust compliance, for example.
Absolutely.
And that definitely facilitates enormously the compliance with these laws, because they become known and accepted, if well done, and accepted in a country. And really, last but not least, you have mentioned these case studies that you realized in India and Pakistan, and you said that you've observed quite. You've observed that the results of the implementation of pretty much very similar body of laws in India and Pakistan are instead the results of their implementation. It's not that couldn't be more different, but diverge quite extensively from one to the other. So can you expand a little bit on these and on the reasons why you believe, you have already mentioned this before, but if you could please expand a little bit on this point and explain to us why you think that this happened in the first place.
So I think that there are obviously many ways of cutting this cake, as we say, but the way I looked at it, I thought that one of the biggest reasons, or one of the critical reasons for divergence in the results, was in the manner in which the laws were adopted. So when the laws are adopted through a more inclusive participatory mechanism, it doesn't have to be full democracy. I want to say that, I think, because a lot of people will say, oh, if you don't have a democracy, can you have no laws? Or if you don't have a good democracy? I think, again, Danny Roderick puts it really well, that it's not that democracy is the only way to create more participatory law reform, but it is usually the best way, because otherwise dictators have no incentive to go to the public. But again, there are many shades of this argument. But I would say that the more inclusive the process of adoption, the more aware the implementation. So I think in Pakistan, what has happened is that, at least in its initial years, so I would say the period between 2007 and 2014 was phase one, and then from 2015 we are in phase two. What we saw was that there was really, the law was so unknown and so ununderstood, if that's a word, that it was impossible to get the public to use it. As you rightly said, if our students don't understand it, imagine how businesses would respond. People thought this was an anti-business law. In fact, there was no clear understanding that this was a pro-business law. It would help entrepreneurship. I think that has led to and that limited awareness has led to a very big divergence in their implementation. Having said that, and I think that's a very important point, that none of this is written in forever. None of this is destiny now, that you can never change it. It can be changed. And what happened in Pakistan in 2014, we talked about how the governments don't support laws they don't fully understand, and we had changes of government, so the support for the law went down. But then the Competition Commission of Pakistan was very resilient at that time, and it invested in advocacy. And that was the investment in advocacy that was missing in the beginning. That advocacy, I mean that creation of awareness, that going to universities, going to talk about what these principles are, creating a broader understanding, making people appreciate that this is actually better for the economy in many ways rather than an anti-economy. That has led to a more intelligent awareness, a more intelligent enforcement from 2014 onwards. In India, actually, we see a little bit of a reversal right now because, again, no situation is constant and fixed in all times or for all times to come. And India found that it had been so focused on doing it the Indian way that, everything, the law had to be adopted in the Indian way, the law had to be contextualized in the Indian way. I use a word, I call it Indianized. Everything had to be not indigenized, but Indianized. And they found themselves to be moving in a direction which was actually not competition, didn't look like competition law at all. And they have had to come back and say, okay, we need to look at the West. And we need to see, for instance, they had this big decision on Google, which was very much modeled after the Google EU, the Google shopping case, and it was modeled after the EU decision on the Google shopping case. So I think they both have to strike a balance. Pakistan has to go more to the people. Pakistan was too aware of itself as this great, it had inherited this brilliant law, adopted this brilliantly written law from the foreign countries. So it didn't really need anything from the public. But I think that there's been a realization that no, it has to go to the public. It has to create that awareness. And I think India has had to have a realization in a different direction that only local acceptance and local legitimacy is not the only thing. It also needs to keep plugged in to that Western development of competition ideas and competition enforcement principles. So I think the divergence, again, to come back to your original question, that why was there a divergence? Because of the adoption process and the lack of inclusivity in the adoption process in Pakistan, and substantial inclusivity in India. But again, that divergence has to be addressed at different plateaus in the implementation trajectory. You need to reconsider where you're going and to redirect yourself in alignment with your goals. So for instance, if my goal as a developing country is economic development, then every few years I need to sit back and reconsider and see, is my strategy aligned with my development goal? In India and Pakistan, the development goals are the same, really. They both want economic growth and economic development. They're both middle-income countries. Sorry, not middle-income countries, but they fall within the lower-income countries, but lower middle. And there's a lot of room for expansion and growth. So I think as long as they can keep their enforcement strategies aligned with their economic goals, they'll be fine. And then the divergence is not a problem. But here, the divergence is not just between India and Pakistan, but there's a divergence between where the countries want to go and where they seem to be heading or not heading. Some of them have stopped at a red light. So I think that's the kind of divergence we also want to think about.
Oh, splendid! Yeah, actually, on the topic of how to design competition law goals and objectives that fit the overall implementation policy, I think that we should open a new chapter, probably write another paper on this, because that deserves definitely an independent development on its own, so an independent research that I think that would be very timely and fascinating, because it hasn't been so far dealt with from the perspective of the implementing jurisdiction. So how these objectives should be matching the implementing policies. That would be incredibly interesting. And I have to be honest, I think that I will have to study it again and again your papers, because you gave me lots of inspiration for my further research. And I believe that since they can be extremely useful for many of the people that hopefully will listen to us, I will definitely link your papers to this video, and so that anybody can go and look at them and more in depth. And really, again, thank you very much for this very engaging description, explanation, and actually analysis of the core issues that you deal with in these papers, and even more because we've been going even a little bit out of the boundaries of the papers. But thank you very much, Amber, again. It was really a privilege for me to have you here today, and hope to see you soon, perhaps for another interview, if you want.
Who knows? Thank you so much, Claudio, for having me. I just want to end by saying that, yes, I talk a lot about India and Pakistan. Both countries are very, very close to my heart. But I think that the issues we are talking about are relevant to all developing countries that find themselves somewhere on the spectrum of, democracy and dictatorship and adopting foreign laws. So I think there's food for thought, rather, for all of us, and to learn from each other's experience and to enhance our own experience of not just competition legislation, but possibly of law reform entirely. So thank you again for providing me this wonderful opportunity, and I look forward to seeing you very soon.
Thank you very much. Goodbye.